Good afternoon. Call Committee of the Whole, Section A to order, and we are talking on Bill 34, the Opioid Damages and Healthcare Cost Recovery Amendment Act 2022. We're on Clause 1. Shall Clause 1 pass? Aye. Member from Abbotsford South. West. West.
Southwest.
Southwest.
West. Thanks, Honourable Chair. When we left off last day, we had a conversation about the settlement with Purdue, and I think one of the last questions I asked was about the division of those settlement proceeds amongst jurisdictions within Canada, and the answer I think the minister gave was that hasn't been settled, hasn't been determined definitively yet. What's the process for doing so, and when might we expect a definitive statement on how settlement proceeds from this action will be divided amongst jurisdictions in Canada?
Minister.
Thank you, Honourable Chair. BC, as we discussed on Thursday, is the lead plaintiff. There haven't been those discussions to date. We, of course, are in touch with other provinces all the time, but I don't have any further information for the member as to when he might expect that decision to take place. Of course, and we're having a broad discussion under Clause 1, so I'm not saying that it's out of order, but it's also beyond kind of the scope of this case, although it's relevant, and we're answering questions as best we can. But in that case, these would be matters between the provinces, but I don't have any information or more information aside as to when that decision would be made.
Member.
Thanks, Honourable Chair. I thought I heard the minister say that there haven't yet, and if I misheard, then he'll correct me, but I thought I heard him say that there have not yet been discussions with the other provinces about the allocation of settlement proceeds. Is that correct?
Minister.
What I'm saying is that the settlement has gone through a number of stages in the process, including the discussions between the jurisdictions. But the process of determining the allocation within the settlement, no decision has been made on yet. And really, I can't, that's a matter as between, presumably will be a matter as between all of the people involved. And I don't have any information to provide as to when that would be. I think the question the member had that I answered was, when are you going to make that decision? And the answer is that the answer that I have is we don't have any further information to provide. So we provided the information publicly about the amount of the settlement. BC is the lead plaintiff, effectively, on behalf of all the jurisdictions, but no decision has been made, and I don't have a timetable to provide as to when that decision would be made.
Member.
Is there a settlement mandate for the Government of British Columbia?
Minister.
Obviously, matters in these processes, and the members more familiar with this than I are privileged in a broad sense. I mean, obviously, the province, and it wouldn't be in the public interest for them not to be, I suspect. But and so, if I understand the question, the member may want to describe it more. More what he's trying to get at more, because we were trying to sort of understand what he was trying to get at, and so he may want to clarify that in further questions. But you know, these are matters as to, presumably he's asking, well, when is a settlement acceptable and when is it not, or a question like that. But these are matters, obviously, in these kind of discussions between plaintiffs and defendants of this action, matters of privilege for our lawyers, and the member would well understand that.
Member.
Thanks, Honourable Chair. I pointedly and purposely did not ask what the mandate was. I asked if there is one. And if there is, how is it arrived at? This is litigation that is designed to ultimately secure hundreds of millions of dollars, if not more than that, in settlement proceeds. There is a settlement that the government has touted as being the product of this litigation that this legislation relates specifically to. What we've learned thus far is that since the announcement of that settlement in June of this year, there hasn't been any progress made around how those settlement proceeds are going to be divided amongst the provinces of BC, but I'm sure the minister would confirm his hope and the government's hope that this is the first of other settlements, and the matter may yet proceed through to trial. But I suspect the hope is that the presence of the litigation will provoke other defendants to come forward and engage in settlement discussions. In fact, maybe that's happening now, and I haven't asked about that. I'm asking, is there a settlement mandate? And if there is, how it was arrived at?
Minister.
Thank you very much, Honourable Speaker. And clearly, the people involved in this in the government of British Columbia are very committed to this process and working hard on it. But in our view, and the advice I receive is that such a question would be, I guess, part of the legal strategy of the government. But to say that, you know, we're obviously preparing and working hard, and our legal teams are working hard, but this is our confidential legal strategies in this question in the action. And in the case of the Purdue settlement, a settlement was arrived at as between in that case, one of the defendants and the lead plaintiff, which is the government of British Columbia, and ultimately that there's an effort to seek that be supported by the Supreme Court, BC Supreme Court, and that's what's happening there. But in terms of what our mandate is, what our strategy is, there's not much more we can say, except obviously, given that we're taking the steps and we've taken the steps we've taken in court, there is one.
Member.
Thanks, Honourable Chair. In the past, a settlement of the sort that the government announced with Purdue arising out of this litigation would have required a review and approval by Treasury Board. Did that occur here?
Minister.
Thank you. There might well, and members of former Minister of Finance sat on Treasury Board. I sit on Treasury Board too, so I understand that in a general sense, there might well be a Treasury Board submission once the money comes in for the expenditure of that money. Right? There might conceivably be that, but it's not the Treasury Board that would be approving the settlement. There would be, in this case, I think, a delegated authority through to the Attorney General or Deputy Attorney General, as the case may be, from the Lieutenant Governor and Council. In this case, because it involves the Ministry of Health, the Ministry of Mental Health and Addictions, and other things, those ministries might be involved as advisors. But the delegated authority is to the Attorney General, effectively, and in this case, that would probably mean the Deputy Attorney General making these decisions.
Member.
Thanks, Honourable Chair. So that's helpful, and I'll repeat what it means to me because I want to make sure, if I understand it incorrectly, the health minister can correct me. What I gather from that is there's no Treasury Board review of the settlement proposal itself. What I heard the health minister say is if and when funds are actually received, which would go into general revenues, the jurisdiction of the Treasury Board to oversee its ultimate expenditure would kick in. I think we understand that. I will say I am surprised that on a matter of this sort, there wouldn't be some Treasury Board involvement in the creation of a settlement mandate. And I'm going to say this again because the minister has been here for a while, as have I. I'm pointedly not asking him to disclose what the settlement mandate is. I am asking and have asked that he confirm there is one, and he hasn't done that, which suggests to me that there isn't one. Why is that significant? It's significant because if, as the government hopes, and I think the minister hopes, there are a series of negotiations, there will need to be something to guide those negotiations, as opposed to what I think I'm hearing about, which is a pretty ad hoc process at the moment. But if the health minister takes issue with anything I think I've heard, or my spin, if you will, on what I've heard, he's quite capable of indicating that to the committee. It sounds like the approving authority for any of these settlements will be the Attorney General or the Deputy Attorney General. Is that correct?
Minister.
Well, there's nothing ad hoc about it, Honourable Chair. We're, in the case of the Purdue settlement, for example, it's been agreed to by all of the jurisdictions in the country. So that's 9 other provincial jurisdictions, 3 other territorial governments. So that's a pretty systematic process. And obviously, the government has a legal strategy and one that we're pursuing in concert with all of those other provincial and territorial governments, and soon we hope, and it's later in the bill, the Government of Canada, to respond to the actions of certain enterprises, and perhaps again, if changes are brought in, their directors and officers with respect to the overdose crisis and in our country, and with respect to opioid damages related to that in our country. So there is a strategy, but the elements of that strategy, including elements that the member's talking about, we can't disclose because it's our legal strategy. But suffice it to say, with this many, with us as the lead plaintiffs, working with all the other jurisdictions in the country, soon we hope with the Government of Canada, we believe that there obviously is a strategy in place, that there have been some results so far. We're going to continue to pursue that strategy, and in addition, the measures that were taken in 2018, the measures that are taken in this bill, will assist the people of BC and the people of Canada in getting the justice that I think they so richly deserve.
Member.
Thanks, Honourable Chair. All interesting, of course, and informative. The question, though, was when a settlement is arrived at, or a proposed settlement is arrived at, that the lead litigant, lead plaintiff, and other jurisdictions in the country have indicated support for within British Columbia, within this jurisdiction. Is it the Attorney General or the Deputy Attorney General who has the authority to sign off and commit the province of British Columbia to accepting that settlement and presumably discontinuing the litigation against that defendant?
Minister.
So, Attorney General or Deputy Attorney General can sign off agreements, but the basis for that and the delegated authority is the Cabinet, the Lieutenant Governor and Council, and that would be the case in all of these settlements. But there may be, should they happen in future settlements and another settlement, they're done under those auspices. So, and given the nature of this, is it's a legal case and the involvement of all the jurisdictions, they work hard together to arrive at the best possible circumstance for people of BC and the people of other provinces. So the authority is the Cabinet. Sometimes that authority is delegated to ministries, ministers, deputy ministers, and that would be the case here.
Member.
Thanks, and I think the Health Minister answered my question in his final statement. So for the purpose of this litigation and the defendants now named in this litigation, has the authority been delegated to the Attorney General to sign off on settlements?
Minister.
The authority is still with the Lieutenant Governor and Council, but in particular settlement, the signing authority for that might well be delegated to the AG or the Deputy AG or someone else.
Member.
Thanks. And was that the case in the Purdue settlement?
Minister.
Yeah, again, the decision is under the auspices of the Lieutenant Governor and Council, the Cabinet effectively, and in that case, the signing would have been delegated to the Deputy Attorney General.
Member.
All right. I'll have one more go at this. in the past where litigation of this sort has and negotiate that give rise to negotiations, and in this case it's as a result of litigation initiated by the province, but there's other types of negotiations obviously that take place between the government and others. The practice has been in advance, or at least prior to arriving at a proposed settlement, to draw up a set of parameters that will guide the decision maker when it comes time to assess a settlement proposal, which is particularly important in a case where there are there are multiple defendants in this case. So for the purpose of some manner of consistency, I would have thought that there would exist a methodology by which a settlement proposal is assessed by the decision maker, whether it is the cabinet or delegated to a member of the Executive Council, in this case the Attorney General, and that would have all been set in place. There are clearly other discussions that happen outside of government as it relates to other provinces and other jurisdictions within Canada, but I'm mildly concerned that at the moment the decision maker, whoever it is, doesn't have the benefit of attempting to fit a settlement proposal within some kind of settlement mandate, and at least have the benefit of being able to advise a cabinet, this proposal fits within our calculation of an appropriate range or does not. Now, the minister may say that is ongoing work, and it's my question / submission is, with the number of defendants at play here, it would seem to me to make sense, and in the past the practice has been to have a settlement mandate in place to fit settlement proposals within, to see whether they meet that mandate. It's a guide. I don't suppose it's ultimately 100% determinative, but it is a guide for the decision maker. If the minister is saying we have that, but I'm not going to talk about it, okay, I understand that to a certain extent, but his answers have left me with the impression that settlement mandate methodology doesn't yet exist, and that is my concern, and I'll let him respond.
Minister.
Well, I want to provide the maximum possible assurance to the member that there is a comprehensive legal strategy, that it's being put in place by people, outstanding people representing us in this matter. So there is a comprehensive legal strategy, but we just can't, as he suggests, and he suggested, and quite rightly, that he wasn't asking for, but that we're just not going to parse aspects of that strategy. But there is a comprehensive legal strategy. I think it's already having signs of success. We're working through that, and those were properly disclosed when the settlement was reached with Purdue. But there is a comprehensive strategy, and we're pursuing that strategy. And a comprehensive legal strategy would include all elements of what we're trying to achieve here on behalf of people in BC. So I think if he's suggesting that there isn't a comprehensive legal strategy, there is, and I think we may be having a bit of a discussion about the words he used. He uses the term mandate. I say there's a comprehensive legal strategy, but the comprehensive legal strategy would include all aspects of the case and our strategy in the case. And obviously, you, at times when you're involved in those sorts of things, the member would know, as a lawyer, more than I, that you might adjust that strategy, but there is a comprehensive legal strategy that we're pursuing this case on, as he would expect. So I don't think he should be concerned about that. I think our team is, we've got a very strong team and they're very committed to this case.
Member.
Thanks, Honourable Chair. I'll only say that I think there is a distinction between a litigation strategy and a settlement mandate, but I have endeavored to make that point to the best of my ability. Is there in the action the government is seeking as plaintiff damages pursuant to the Healthcare Costs Recovery Act and also the legislation that this is amending? Has the government quantified, calculated and quantified the nature of those damages? Again, I'm not actually, I haven't yet asked what that amount is, but have they quantified that amount, and do they have a figure?
Minister.
Thank you, Honourable Chair. The answer to the question is yes. And secondly, with respect, obviously, to the overdose public health emergency and some of the issues involved in opioid damages, it's a number that also we would expect, sadly, to increase over time. But the short answer to the question is yes.
Member.
Thanks, Honourable Chair. Well, I'm at least obligated to ask what it is.
Minister.
And I'm equally obligated to say that that's part of our comprehensive legal strategy.
Member.
Let's now get into parts of having canvassed some of these general issues in Section 1. In Section 1 Sub A, or I guess we call them Clause 1 Sub A for the purposes of the committee. Two changes in definition there, or two additions. One relating to active ingredient. I'm not sure how much time I necessarily need to spend pursuing that and the schedule. There are some sections, a couple of clauses further on, actually I guess subsections of Clause 1 that I may ask the Health Minister to expand upon the distinction and the importance of that addition. I'm more interested at the moment in Clause 1 Sub A, Sub A, and the addition of the definition of consultant. And I guess the first thing to verify and confirm with the Minister is this is a purposeful decision and attempt by the government to add a new class of potential defendants. Is that correct?
Minister.
Yeah, yes, and I think, as the member will know, it's also analogous to parallel legislation that have been brought forward in Saskatchewan, but yes.
Member.
So the language, as always, contained within these legal instruments is important. And consultant is defined as a person who provides advisory services to either a wholesaler or a manufacturer, and those are previously defined terms. Those are both classes of defendants that exist under the existing action. But the government is now choosing to amend the original legislation to include those who provide advisory services in the case of a wholesaler in relation to the distribution, sale, or offering for sale of opioids, in the case of a manufacturer in relation to sale of active ingredients or opioid products. In both those definitions, the word sale occurs. My reading of the legal text is that it is sufficiently broad to allow for the adding of a salesperson, an individual salesperson working with either a wholesaler or a manufacturer. Now, I should say I have been advised in briefings that the intention of the government may be different. I want to make clear that I have received that information. Our job in these proceedings, though, is both to clarify what the intention is of the present government, but also how the instrument could be used if those intentions change. Therefore, my question is the language sufficiently broad, as it appears to me to be, to include an individual salesperson?
Minister.
Well, first of all, it's important to say what the intention is. The intention is to capture, in particular, corporate entities that have been involved in relevant consultancies where it would be appropriate to bring an action, right? And so that's not individual salespeople, although, and there are other changes we're bringing in later as well to the legislation, which we'll discuss later, that could involve an individual, but individuals who are working for a company would be taken up in the work of that company, right? So an individual who was working as a salesperson for Purdue, for example, would be taken up in the case with Purdue. In this case, in terms of the consultants, the intention is to capture those entities, and that's the purpose of the legislation. If an individual in some fashion were to be named in that circumstance, such as a salesperson in the member's example, they'd have to be named as a defendant, and that would be quite unlikely.
Sorry, quite.
Member.
Thanks, Honourable Chair. Maybe the best way and most efficient way to proceed, I was a bit unfair to the Minister. I should have allowed him to start off by explaining the overall intention of the addition of consultancy, and I think he can do so by pointing, for example, to the action that has, the separate action that has been launched against the company McKinsey, which I understand broadly fits within the category of what the government is seeking to do here. So maybe he can advise give us a slightly broader description of what the overall intention. Then we'll come back to whether or not the definition is broad enough to capture others that may not be the primary target. And I've talked about one, which is salespeople. There may be others, but let's start. Let's start with the primary intention of this government at this time, as it relates to the creation of this new class of possible defendants, and if the Minister wishes to do so with reference to the action that was commenced back in December of 21, then that might be helpful.
Minister.
Thank you. So we had some of this discussion last time, and including on this specific question. So, but it's good to bring it back into this time, so we know what we're talking about in general. And I appreciate the opportunity to do so from the member. The purpose, I think, is to include and bring into the scope of the Act those parties who worked with a manufacturer distributor, or a manufacturer wholesaler, excuse me, by assisting in designing, recommending, and implementing strategies to increase sales of opioid products. And so this has been brought in to the Act here. So that is the purpose of it. And you see, with respect to the case from December of 21, an example of that. So that's the purpose of it. And obviously, it's our view that some people who hold some accountability there who are under those circumstances, and that's why we've included a consultant in this question. So, in a general sense, respond to his first question again, and we'll have a chance to go over sort of the scope of this. In a general sense, the salespeople might be marginal to that, but they would probably be working for that company in the case of the consultant company, but they would be unlikely to be individually, and that's why I gave them the response of unlikely to be dealt with here. What we're looking for here is the kind of thing we've seen in the case in December, and people who know the issue know well of the role of consultancies, and make sure that they're included in the scope of the action and the legislation should that be justified.
Member.
Thanks, Honourable Chair. The one example we have of this, and what I believe has contributed to the amendment before us, but the Minister can confirm that, is the action that was commenced by the Crown and the right of the Province of British Columbia against McKinsey. I'm not going to ask the Minister to read into the record 30 pages of the notice of claim, but it might be helpful for him to summarize in effect what the allegation or what the claim is about the conduct of McKinsey that the government seeks compensation for, as an example of what the government says and claims is improper conduct on the part of a consultant.
Minister.
So thank you very much, Honourable Chair. And I won't read into the record, as the member suggests, the entire action. He wasn't asking for that, but just to give a sense of what that action is. And we'll go through and you can really see some of the key parts of that starting at page 11. And I'll just summarize it, perhaps without including the following, so the member will have a sense of that. That McKinsey worked with opioid manufacturers, development and implement marketing strategies built around a pattern of false and misleading representations regarding the safety and efficacy of opioids. Through its consulting work, McKinsey, along with opioid manufacturers, made false and misleading representations to medical professionals and members of the public, which included the following, and then there's a list from A to H, which perhaps the member can refer to, and members of the public who are interested can see, since this is all public. On page 12, it says McKinsey knew or ought to have known that opioid misrepresentations were not supported or were contrary to scientific evidence. McKinsey knew that doctors and patients rely heavily on educational materials, such as treatment guidelines, continuing medical education, seminars, articles, and websites to enforce them of treatment decisions. It goes on to say, McKinsey's false, reckless, and deceptive marketing campaigns were carried out through the following acts, and then there's a series of those acts listed, which people can review, and I'm sure the member has reviewed. And during the class period, McKinsey promoted opioids by working with opioid manufacturers to develop and implement strategies to include sales, including but not limited to, and then we go A to K. And then McKinsey was instrumental in developing tactics to market and promote opioids in Canada, despite McKinsey's knowledge that opioids were addictive and were being aggressively promoted to treat conditions like that opioids are not effective in treating. And it goes on from there. And so, and there's obviously a lot more to it, including the relationship, for example, with Purdue and others. So, and therefore it concludes, amongst other things, and there's a number of these, and it goes on, as the member says, for many pages. McKinsey has created or assisted in the creation of an epidemic of addiction in British Columbia and throughout every province and territory in Canada. The actions of McKinsey have caused deaths and serious and long-lasting injury to public peace, health, order, and safety, significantly harming the plaintiff and impacting its ability to deliver health care to the citizens of British Columbia.
Member.
Thanks, Honourable Chair, and to the Minister. So this action was commenced not quite a year ago, at the end of calendar year, and the 30th of, someone was working over Christmas last year, on December the 30th, 1921. Presumably on the strength of advice that the government received that it could sustain this action against, successfully sustain this action against McKinsey. The notice of civil claim includes reference to things like the Healthcare Costs Recovery Act. So what has prompted the amendment, if the government was of the view that the body of law and existing common law negligence law and tort law allowed for the commencement of the action almost a year ago, what has prompted the amendment, and how does that alter the strength of the action against McKinsey? And I guess the third part of that question, someone's making notes, is that going to necessitate an amended notice of civil claim in the McKinsey action, the passage of these amendments?
Minister.
Really, for the same reason, I'd say that we brought forward the legislation itself in 2018. There was, of course, an action in advance of the passage of that legislation. What happened in that case was an amendment to that action to include the legislation itself. And it just ensures that the provisions of the Act would apply, in this case, to McKinsey, but potentially to others. With respect to the statistical evidence and the population health evidence that could be brought forward could be applied to them as well. So just as the original act, or the act we're talking about that's being amended here, assisted in ensuring that the action was taken and justice was pursued, equally in the case of the action with McKinsey, that the same application of the law, what we're doing is pretty much exactly the same as we did when we brought in the legislation and applied it to the manufacturers and wholesalers. In this case, we're applying it to consultants, and that would bring the provisions of the Act into force in that case. The member, and so he asked in future whether we would amend the case accordingly. That was the pattern before. That's obviously a decision for the lawyers to make in the future, but that would be a likely course that would be amended to include the passage of legislation directly relevant to it.
Member.
Thanks, Honourable Chair. And is it the government's view and submission to the committee that the passage of this amendment strengthens the case it is pursuing against McKinsey specifically and any other consultant that it might identify?
Minister. Member.
Thanks, Honourable Chair. We've talked about, in general terms, the likelihood of individuals being named as a consultant defendant. Come back to that in a moment. in the category that the government has already demonstrated, in the category of consultant that the government has already indicated by its actions it intends to pursue McKinsey. Are there other similar consultant organizations that the government and the minister can indicate it intends to add as defendants in the future? Again, I'm not asking the minister to identify by name, but is McKinsey likely to be the only consultant defendant, or will there be others?
Minister.
Well, obviously, our thinking applies to McKinsey because the action has been taken. We can't say whether there's others, but by definition, because we'd be passing the legislation, should be passed by the committee and the legislature, that creates that possibility. But we can't say more about whether there's either one or more other persons in that sense, like we mean corporate entities, but persons who would be the target of that action. But we do understand, because we've taken the action against McKinsey, that would be the case. But beyond that, that's obviously would be a confidential question, our legal strategy. But what I think is important for the legislation is that, yes, that's the questions the member's asking us. It is possible that it could apply to others as well.
Member.
Thanks. I'll just try this one other way that hopefully is sensitive to the considerations that the government and the minister have to contend with. Is the government and the ministry, or the government generally, aware of other agencies, corporations that engaged in behavior and activities similar to that identified by McKinsey?
Minister.
I very much appreciate the member asking the same question in a different way, and that is a skill that may not be generally valuable to us in the world outside of politics, but it is definitely a skill in this area. But I think the answer is really the same as the previous answer, right? You can see by the action taken with respect to McKinsey that the very significant case the government is bringing and the standard it's bringing, and can't really say, again, if there's a list or if there's people who are equivalent to McKinsey, can't really say if there's other people, except that by passing this legislation, including consultant, there is, of course, the possibility of that. Right now, though, there's one company in that position, McKinsey, where we've already taken action. You can see the nature of that action.
Member.
Thanks, Honourable Chair. We were speaking a moment ago about the difference between sorry, I shouldn't say the difference, about the specific definition of consultant, how the government intends to make use of that and has made use of that with respect to McKinsey, and I think the term the minister used was something akin to not likely that we would see individual consultants, salespeople was the example I used. But can I ask this, assuming this section and the subsequent sections were to pass, am I correct in saying that not only because of the proposed changes to the original legislation contained in Section 10, the passage of these amendments would expose the individual directors and officers of a consultancy like McKinsey to the joint and several liability provisions contained in Section 10. A long-winded way of saying, once an action has been commenced against a consultant within the meaning of this act, it is not just the corporate entity, but certain individuals within that consultancy who can also be named. Is that correct?
Minister.
The answer is yes.
Member.
So coming back then to the example I raised earlier, which will I think be of more than passing interest to some of the individuals involved in the purchase and sale of pharmaceutical drug products. We have, I think, ascertained that an individual salesperson can fit. And I say an individual salesperson or a smaller sales agency can fit within the definition of consultant contained within the Section 1 amendment. Is that correct?
Minister.
So I think the key word here is advisory services, right? The key two words I would say are advisory services. So a salesperson who might be out, as there are many people out at any given time, working on a sales campaign is not the same as providing advisory sales that guide that campaign. Right? So when the member talks about the individual salesperson, this is what we typically call a consultant that is being addressed here, and that's what we're trying to do. I think sometimes in the sector they're called drug detailers, right? That's not it's not the people who are selling a product. They would be captured under the company's responsibility if, say, a company, let's call it Company X, decide to hire people to essentially detail, which is a way in a prescribed product of selling a product, that company would be directly responsible. This is people who provide advisory services either to a wholesaler or to a manufacturer. And by definition, that advice is strategic in nature, and that's what we're seeking to get here. So in the sense that the member might mean a drug detailer or a salesperson, I don't think that's what the legislation is seeking, because they're not really providing advisory services that are strategic in nature.
Member.
Thanks, Honourable Chair. Is it sufficiently broad to capture an advertising agency or advertising agent?
Minister.
I think yes, but again, if the next question is, are there some who meet the test of that? I don't think I'd be able to describe that. But I think the easy answer is yes, that it could.
Member.
Right. I wasn't actually going to ask the next question, but I was going to, in terms of scenarios, we can think of examples of advertising agencies and individuals who would have worked closely with manufacturers to promote the distribution and sale of some of the products that are captured that contain the active ingredients stipulated within this act. Let me ask this. Is the definition broad enough to capture a physician that has provided consultancy services, advisory services to a wholesaler or a manufacturer, an individual physician?
Minister.
The relevant thing isn't whether they're a physician or an economist or whatever. The important thing here is providing the advisory services themselves at a strategic level, and that's the purpose of it. So conceivably, someone who is a physician could be providing those services or be responsible for that, but it's not so much in their capacity as a physician, but their capacity as providing the advisory services that this would apply to them.
Member.
Thanks, Honourable Chair. I'm going to grossly oversimplify a 29-page document. I mean, the essence of the claim is that there are people out there, agencies out there, corporations out there that provided misleading information about the impact and effect of these products in a whole host of different ways. And I think my question is, to the extent that, and we have focused on corporate, well, when I say we, the action at the moment focuses on corporate level defendants. These amendments now, in two possible ways, speak to the inclusion of individual defendants, corporate directors and officers, and possibly, and that's what we're exploring here, individuals who would have been providing advisory services that assisted in these corporations in advancing their agendas that the government is seeking to collect damages from. So again, the likelihood or possibility that either a manufacturer or a wholesaler would have received from a physician advisory services about a product that they would have used and would have assisted them in conducting their business elsewhere is the purpose is the purpose of the section, to create the option at least of naming, in this case my question is, an individual physician who may have provided advisory services that assisted those manufacturers or wholesalers.
Minister.
Well, yeah, I think that, and we can, it's not a problem to discuss all the clauses under Clause 1, but the member is quite right, that the provisions relating to officers and directors would apply to all of the categories, so the wholesaler, the manufacturer, now the consultant, so it would apply to all of those categories. And he's quite right. That means that action can be taken in those circumstances. We sort of set the standard of what we're looking for with respect to consultant. In the McKinsey case, we don't rule out that it could be used against others, but that's the standard of it. And so I don't think the issue, but what it means, and we've already established this, the member asked this in a previous question, is that there could well be officer or director liability in those cases, whether it's a consultant, whether it's a wholesaler, or whether it's a manufacturer. So I think, and you wouldn't rule out, for example, let's say a one-person consultancy, right, which would be the consultancy, and that you wouldn't rule it out. But if you look at the case being brought here in for example, in the McKinsey case, and people can see the government's case and reflect on that, I don't think you would see that. I think you could potentially see the provisions involving officers and directors apply to a consultancy as with the others, but I don't think really this doesn't really apply to, say, an individual doctor who might be prescribing a product or anything like that. That's not the intent. This is strategic advice provided to a company in the way that McKinsey, in our view, and in our presentation in court, provided such strategic advice, contrary to, and the consequence of which were opioid damages.
Member.
Thank you, Madam Chair. And again, that's helpful. And to be clear, I wasn't suggesting that the provision might expose an individual physician who has prescribed a product to a patient to liability or being named as a defendant. But I was suggesting that the subsection could be used to name an individual physician who has provided advisory services to a manufacturer or wholesaler, and that physician would not need to be a director or officer of the company, but could be operating individually in their own right in providing advisory services to a wholesaler or manufacturer. And that is that's my question.
Minister.
I don't think the important thing is that they be a doctor or not, or whatever other status they'd have, or expertise they might be attempting to bring to bear. If they're an employee of the company, not a director or officer, then their potential issues are with the company, with the action against the company. So if they're not a director or an officer of a company X, right, then the action is against company X, not them as an employee of that company. If they're acting as a consultancy, whatever their status, whatever their professional status, then we take action against the consultancy. If say it was a one-person consultancy who was the consultant and the president of the company, say, then they'd be accountable under that provision. So I hope that's helpful to the honourable member.
Member.
Thanks, Honourable Chair. I think my final question on this, the release that is proposed, and I'm not sure it has been executed yet because the settlement with Purdue hasn't finally been approved through all the channels, and we went over that the other day. But I presume the release being proposed would take into account the amendments and what would be newfound personal liability exposure under these amendments, so that the release will be structured in a way that would also release anyone, consultants, directors, officers associated with Purdue. Is that a fair assumption on my part?
Minister.
Thank you very much, Honourable Chair. With respect to any potential release, that would be obviously part of an agreement. So if there were officers and directors of a particular company which negotiated a release against, a settlement, that would be included in that agreement. Wouldn't necessarily affect a consultancy unless they were specifically a part of that agreement.
Member.
Thanks, Honourable. Right, I understand that. Thank you. That's as I thought. All right, we're still on section 1, but I thought we'd turn our attention now to the if passed, when passed, the Bill 34. I'm going to characterize it this way: extends a form of statutory invitation to the federal government to do something, and I'm wondering if the minister might. And I'm going to ask these questions as part of our discussion of Section 1. The other logical place would be Clause 3, but if we cover it here as it relates to Clause 1 sub. Clause 1 sub B. On page 2 of my bill, we won't have to recanvass it when we get to clause 3. So the amendments, if passed, extend this, provide this opportunity, extend this sort of invitation to the federal government. What are the options for the federal government following passage of? What are their options, and what is the government minister's expectation, if any, about how they will take advantage of the or make use of the passage of these provisions?
Minister.
This allows the federal government to join our potential class. This class hasn't been certified. We've had this discussion before, and to make its own claim to costs of healthcare in this action. So it allows them essentially to join with all the other governments of Canada in this action. Obviously, healthcare benefits provided by the federal government are somewhat different than provincial governments, but this allows them to do this, to join our action here. And obviously, the participation of all governments in that respect strengthens our action, and also, I'd argue, make it more coherent and comprehensive for both sides in the discussion.
Member.
Join the class. Thanks, Honourable Chair. Join the class. Commence their own separate action, or do nothing. Are those broadly the three options available?
Minister. Member.
And has the government received an indication from the federal government which of those three options they are likely to explore?
Minister.
I'd say the federal government is supportive of the legislation and the approach, but what their intentions are is privileged, and not privileged to me, but privileged to them, right? But as well, but they are supportive of this, and obviously that means they like the fact that this the passage of this legislation would provide them with some options.
Member.
All right. In the spirit of earlier linguistic gymnastics, I'll try this in a way that doesn't compromise anyone's. My sense is that the Government of Canada has expressed in the past an interest in joining this action. Is that a fair comment on my part?
Minister.
I think, if I might put it this way really directly, I think they've supported this action, and they're also a party to the Purdue settlement and support it as well.
Member.
The purpose of the amendment is to facilitate involvement in one of the two ways that we have discussed by the federal government. As the minister has pointed out, the quantification of their claim, the damages that they would be seeking to recover, are slightly different. What in passing this legislation, presumably the provincial government has some notion or understanding of what that would be. Would be an appropriate time for the minister to relate to the committee what he believes those costs and expenditures would relate to, as distinguished from claims by the provincial government, recognizing the fact that healthcare constitutionally falls within the exclusively the provincial domain, although there are some exceptions.
Minister.
This allows them, for example, Canada, as the member said, expresses its jurisdiction in terms of healthcare, in terms of often military, or in terms of Indigenous people. So we went through the process. The member will be well familiar in the creation of First Nations Health Authority here, which was very much an extension of the federal role in that area. There's a federal role with respect to refugees, which has become a subject of interest recently because by not defining people settling from Canada to Canada from Ukraine in the wake of the war as that, but as other things, it falls within provincial jurisdiction. So you see that there. And then they can fill in other elements. What there isn't is a double capture. So they give us money in the Canada Health Transfer, which you're using to express that. They don't get to, there's not a second bite at the apple there on their Canada Health Transfer stuff. That goes to the provinces, and that expenditure is the subject of our action, right? But there are a series of federal interventions in healthcare that this assists in them pursuing, and there may be others, and it would be for the federal government to see that. I don't give those examples to put forward an exhaustive list for the committee, just to say that those are examples of the expression of the federal interest in healthcare.
Member.
Thanks, that's helpful. And were the federal government to exercise the option of joining this action, and this is purely a procedural question that I'm sure council can advise, do they become a named plaintiff along with the government of the right of province of British Columbia? And do the pleadings then get amended to include the specific examples of the sort that the minister has just related to the committee?
Minister.
Thank you very much, Honourable Chair. And just one very important area that the member will be well familiar with is our federal penitentiaries. That's another area in the provision of healthcare services there. But again, it's not an exclusive list, but it's an important one, important in the subject matter now as well. So that's significant. If BC is now the lead plaintiff, the class is approved, the federal government will be able to join that class. So it's not necessarily a question of amendment, although they would be able to join that class, and the class would be set, and then we go forward, and the classes, of course, includes the jurisdiction, so it would include the federal government.
Member.
Thanks, Honourable Chair. All right, let's just go down to 1 sub D. And this is where that definition of active ingredient and the schedule contained in the original act become relevant. And I just would like the minister, if he can, to explain the relevance of the change here, because this is a question as opposed to a statement. But it appears to me that that through the change being proposed here, the potential liability relates now not just to a product that contains an active ingredient, but the manufacturer of the active ingredient itself. And if I'm wrong about that, I'm sure the minister will tell me, but there's clearly an intention to change something, and I'm not entirely clear on whether I properly understand what what that change is.
Minister.
Thank you. I think it's to make it airtight and prevent an argument of, I'm only in a manufacturer of an active ingredient, but not of the product. So it just makes it very straightforward that you are potentially liable under those circumstances if you're a manufacturer of an active ingredient. So it's just making it very clear that that is not a potential way of avoiding that liability, and that with respect to the Act, manufacturers of active ingredients can be held liable, will be held liable, can be held liable for their actions.
Well, shall clause 1 pass? So ordered. Shall clause 2 to clause 7 pass? So ordered. On clause 8. Of course, sorry, member.
I feel forgotten.
I was just rushed off my feet.
Thank you, Madam Chair. 2-year limitation period as it relates to any action that the Government of Canada would commence, either, I presume, by joining or its own independent action. When does that 2-year period run from?
Minister.
So thank you. It's I'll just share this. This note: the federal government will have the ability to commence action within 2 years of the coming into force of the new subsection, without the action being considered to be out of time or statute barred under the Limitation Act. So it's the coming into force of the section, which is what the member was looking for.
Member.
Right, and I can't remember. So royal assent in the act, these amendments come into force on royal assent. So from the moment royal assent is granted, the federal government will have 2 years within which to decide whether to join the existing action or to commence one of their own if they wish to avail themselves of the provisions of this and the original opioid legislation.
Minister.
Yes.
Member. Shall clause 8 pass? Aye. So ordered. Shall clause 9 pass? Aye. So ordered. Shall clause 10 pass? Aye. Member.
Thank you, Honourable Chair. Can I ask the Minister, with the assistance of his team, the language as it relates to imposing some measure of personal liability, or as we used to say, piercing the corporate veil to impose personal liability upon directors and officers, is that taken from other legislation, the Business Corporation Act, or is there something unique? Well, it's unique in the sense that it relates to a very specific action, but is this taken from another piece of existing legislation?
Minister.
So it's not modeled on a specific piece of BC legislation. It is found in the provision and model on analogous legislation that's been passed in Alberta, Saskatchewan, Nova Scotia, and Prince Edward Island. And so those statutes were enacted after British Columbia's original statute, and so it's modeled on those, but it is, in that sense, not modeled on a similar provision in an existing statute in BC.
Member.
Thanks, Honourable Chair. So as I understand it, the intention here is, and it's written out in the clause, what will be 7.1 in the original act. In circumstances where a director or officer has done some of the things contained in what will be 7.1 sub 1, they can attract a personal liability that is a joint and several liability. And in 7.1 sub 3, there are provisions that excuse that liability if the director or officer can establish one of the following things: that they've been reasonably diligent or didn't know, are the two specific defenses that are available. So if I've got this right, the plaintiff can allege this behavior on the part of a director or officer, call evidence to that effect, and the burden then shifts, the onus then shifts to the individual director or director or officer to demonstrate that notwithstanding that evidence that the plaintiff is called demonstrating their involvement, if they can demonstrate having acted reasonably or not having had knowledge, they can escape that what would otherwise be personal liability. So have I got the sequencing and the test correct?
Minister.
Yes.
Member.
So it would seem to follow, therefore, that prior to any trial of the action taking place, if the government, on behalf of the class, if the class is certified, wishes to pursue liability individually against directors or officers of a manufacturer, a wholesaler, or a consultant, they'll have to name that director or those directors and those officers as individual defendants in advance of the action proceeding to trial. Is that also correct?
Minister.
Yes.
Member.
Thanks, Honourable Chair. So this next question, I'm going to preface the question this way because I hope the Minister will agree with my proposition that piercing the corporate veil in the way that this does is unusual. It's a departure from the usual rules around corporate. There are some exceptions to where corporate directors and officers can be held personally liable, but generally not. So it is the creation of a fairly extraordinary, or I'll say extraordinary, exceptional mechanism. We've established that in order to make use of it, the government will need to name directors or officers individually as defendants. The government is asking the Legislative Assembly for permission to do that. In those circumstances, I do think it's a fair question to put to the government here at committee stage. Does it intend to use it? Does it intend to name individual officers and or directors as individual defendants in this action?
Minister.
Thank you. I always like to give as direct an answer as we can, understanding that that's legal strategy, right? And so we're not announcing today our intention to take action against particular individuals, but clearly, because it's included in this action, and this is also a very unusual legal action. I think the only real comparison we can draw is the tobacco action, right? Those are the two actions. And the nature of opioid-related wrong, which is a tort that is committed in BC by a manufacturer or wholesaler, and now we're adding another provision, but that's an existing act, and that causes or contributes to opioid-related disease, injury, or illness, and that continues, right? So it's a very unusual action. So the purpose of doing this is absolutely to establish the possibility of doing that. Not that whether we decided to do that, that will be an aspect of the strategy going forward, that the people directing the legal strategy, and I won't be announcing here. But clearly we think it's important enough to bring it to this legislature and to establish that possibility in law, and that's what we're doing.
Member.
Thanks, Honourable Chair. I'm going to push back a little bit on this one, and I'll explain if I can, my rationale for doing so. So when the original, I think it was Bill 38, was the original bill in 2018, was passed, the government was in a position to say, and did say, we are seeking this legislative authority to enhance our ability, strengthen our ability to pursue this case against manufacturers and wholesalers of opioids, and actually could point to an action that had been filed several months previously. So demonstrably it was able to say to the Legislative Assembly, we are seeking this extraordinary instrument, this extraordinary legislative instrument, and we intend to use it. In fact, you have already seen us use it. And on that basis, we seek the Legislative Assembly's acquiescence and support for enhancing our prospects in that regard. And the Legislative Assembly spoke and I think provided fairly expedited passage of the legislation at the time. now 4 years later, in the midst of that action, which is proceeding as they do, the government has come and said, we want to expand the range of possible defendants, and they've said in two ways. Consultants, and again, the government was in a position to say, we will use that tool. We can't say for certain how extensively, but we'll use it because we already have. It comes to the final potential expansion of defendants. We want the Legislative Assembly to grant us, the government, the Crown and the right of Province of British Columbia, the right to pursue individuals associated with these defendant companies in a way that we otherwise would not be entitled to. That is a powerful instrument. I don't think that's an exaggeration. But in this case, the government isn't able to point to a previous step that says to the Assembly, we're willing to use that new tool. And it is, I think, appropriate, and I would not expect the minister to stand up today and say, we intend to use this tool to name the following individuals with the following companies. I would expect him, though, to advise the committee and through the committee the Assembly as to whether or not the government intends to use this tool to name individual directors and officers, or is this simply an instrument that intends to wield as a negotiating tool? That's all strategic. But I think the Assembly is entitled to know whether or not the government intends to use this tool. And the minister's saying, I'm reluctant to tell you that. But I think it's, for the reasons I've alluded to, fair to press the government for a commitment as to whether or not the tool is going to be used.
Minister.
Thank you. And if I was going to say if it pleases the court, but I won't say that. Although it's a little like that, but I'm going to ask if that's possible for a 5-minute recess after I answer this question. That's okay with the member for Abbotsford West. Just to say that I think there was a logic to his demonstration. We could and we did launch the action in advance of the legislation. We could do that, and we did. In the case of the McKinsey matter, we could and we did. In our view, these changes strengthen that case. In the case of, as he puts it, piercing the corporate veil, that wasn't possible in advance. So there is a difference between the two. I follow his thinking and his law, but there is a difference between that. That's a real difference. What I would say is that it's the purpose of doing this, taking this step in what is an extraordinary action. Really, there are two such actions that we can think of easily of this kind in our history. The purpose of including this is because of the very real possibility of using it. Can't say what the strategy is in advance. It's different than McKinsey, where we've launched the action, so we can say we've launched the action, here it is, and we read from that action. So it's different in that sense. But I think it's fair to say that, to the honourable member, that the purpose of bringing forward this legislation is because of the real possibility of its use. And with that, I think if we could have 5 minutes, I'd most appreciate it.
Wonderful. So we will take a 5-minute recess and return at 10:02. We're going to call the committee back from recess. So we are continuing consideration in a committee of the whole on Bill 34. Over to the member for Abbotsford West.
Thanks, Honourable Chair. With respect to Clause 10, the point has been made that several other provincial jurisdictions have, this language is taken from legislation passed by several other provincial jurisdictions. Have any of them taken steps or announced their intention around the naming or pursuit of individual corporate officers?
Minister.
The answer is not as yet.
Member.
Thanks, Honourable Chair. I will signal to the Minister and the committee that I think I'm drawing close to the conclusion of my questions on the bill. I wanted to ask this, though, and it's more of a general question. I suppose it touches somewhat on liabilities that could accrue to individual corporate officers. So I'll ask it. I'll ask it here. The conduct that the government points to in its notice of claim and points to in seeking compensation under the various statutes and the common law on the part of these defendants, the ones that are named so far and potentially ones in the future. Is the government concerned that some of that conduct continues today, is ongoing?
Minister.
Thank you very much, Honourable Chair. The first thing is, and it's obvious, and it's not direct to the member's question, but we know that the consequences are being felt now of those actions in every community in our province and our country, I would say. So that's an obvious thing, and it's not the answer to his question. I mean, this action on this section says to everyone what the expectation is and the responsibility is. And knowing that doesn't stop people necessarily from not following the law always, but it certainly puts everybody on notice about what their responsibilities are now and into the future. And so in that sense, I think it's a potentially positive thing in the present. And so it would be our hope and expectation that people in the present aren't knowingly doing the things that are noted here, including creating opioid-related wrongs. That would be absolutely our hope. The passage of this legislation makes, in this section, makes some of those responsibilities for individual officers and directors very clear. And I hope that would have as well, should it be required, a salutary effect on their conduct.
Member.
Thanks, Honourable Chair. I'll explain to the committee why I asked the question, because firstly, I won't quarrel with the proposition that the consequences of conduct visit tragically for an extended period of time and remain with us today. The reason I asked the specific question is that the point has been made through various communications documents and in the course of discussions and debates about the government's desire to utilize all the tools at its disposal. In this case, it has created a series of tools and is deploying them through the legal system. It has enjoyed a measure of, I think, support, bipartisan support from the House. But if there is a concern that the message has not been received and conduct of the sort that gives rise to the action in the first place is continuing on the part of certain defendants, then it strikes some people and me as well that there are perhaps some interim measures that the government might consider, injunctive relief as it relates to the conduct of manufacturers and wholesalers and now possibly consultants. So that is one option. I don't profess to be an expert or near an expert on the broad range of products that contain the ingredients that are referred to in the schedule and the schedule itself. I do know that they are they appear in products that are made available through prescriptions as laid out, and they are products that are moved through the drug approval process, over which governments maintain some measure of control. And so the question begs asking at a certain point, as this litigation proceeds and takes the time, we're now into year 4 or 5, if the government is concerned that the conduct is continuing while that litigation is proceeding, there are perhaps some other things that government could do in terms of injunctive relief or placing caps. One of the allegations is dispensation of opioid products well beyond the amounts that should be dispensed. And so the question is, if that's continuing, and I don't know if it is, I don't have the data, I don't have access to the data, but if it is, aren't those additional tools and options that the government could utilize while pursuing this litigation, to take advantage of to make use of its regulatory authority as it relates to the dispensation of these opioid products. So it's a question that when I was having a conversation a week or two ago with some reasonably informed people, that they said, okay, fine, you guys have approved this litigation, but in the meantime, what other safeguard actions are being taken to ensure that this behavior that has been identified as having been so egregious and led to such tragic circumstances isn't continuing, just a little better camouflage than it once was?
Minister.
Thank you very much, Honourable Chair, and thank you to the member for his question. I think the short answer is we need to take all the steps required. I'll give the member an example in this area. A number of years ago, the previous government did this, and we dramatically, significantly added to this. We added what are called academic detailers. In other words, people who provide independent information to doctors. The Therapeutics Initiative, to a degree, plays this role, but also academic detailers, to provide independent information about the impacts of prescription drugs to doctors, independent of sometimes the role of drug dealers who work for drug dealers. Drug detailers is the term I'm looking, drug detailers, to be clear, who might work for a pharmaceutical company whose role it is to promote the use of that drug and its effectiveness and so on. So we need to take all of those steps. I absolutely agree. And we need to take this action. And I would add that actions similar to this in the United States have had a positive effect in telling the public what's going on. The agreements, and part of our case here is to provide information, and not just to seek damages, but to obtain information. That shining a light on things has helped, I would argue, in other jurisdictions, as it helps here, in providing the public with information about what has gone on and ensuring that it does not happen again. So this is not exclusive of other actions that we would need to take, regulatory or otherwise, to deal with the overdose public health emergency or the broader issue of opioids and their impact on our society. Certainly not. But it is an action that contributes to that has other benefits than just the direct action, although those have substantial potential benefits as well in terms of the resources they might provide and the information they provide. But I think it's fair to say that these actions here and in other jurisdictions have had a very significant and positive effect on public understanding and have changed behaviors. So it's not one or the other, it's all.
Minister. Sorry, member, sorry.
He briefly had a spring in his step.
Apologies.
That's the way.
I was still on the previous question. Now I'm going over to the member for Abbotsford West, and
Almost.
I'm in the same room as you now.
I almost bought a new car.
Not a used one, though.
Another house.
Back to the member. We are on clause 10.
We are. I think I've come to the end. So I'm going to try this, put this to the minister, and he'll have an opportunity to the person who would say this to those of us who legislate and those of us who govern, would say, you have made this allegation that you are pursuing through the courts that these manufacturers and these wholesalers have flooded the market with and flooded consumers with these products, which has ultimately had, in many cases, a very devastating effect and life-ending consequences for so many people. Okay, good. But pending the outcome of that, and knowing what you already know, and given the allegations that have been made, why haven't you taken steps to, through regulation, to limit the distribution of these products? Why haven't you considered the possibility of delisting some of these products? Bravo, pursue the action, but the action reveals allegations that need to be pursued and for which compensation needs to be achieved. But in the meantime, there are some other things that can be done that speak to injunctive relief and interim orders, that you are already arguably in possession of information that you could use to justify those applications. So I accept what the minister's saying about multiple tracks and multiple tools. There are people, though, that will look at this action, see the nature of the allegations and claims contained within it, and say to all of us legislators, well, if you knew that, wasn't there something you could do to address that independent of a settlement with these defendants, independent of a decision and verdict from the court?
Minister.
I think I'd say that the purpose of the action is to recover healthcare costs that resulted from the wrongful conduct of opioid manufacturers, distributors, and consultants. That the allegation is that these manufacturers, distributors, and their consultants engaged in deceptive marketing practices with a view to increase sales, resulting in increased rates of addiction and overdose. If there are other actions we should take those actions. And those don't just include these companies, but the actions that are being taken here is to hold people accountable. And that holding of people accountable, I would argue, from here to West Virginia, to other jurisdictions in the United States, to other parts of Canada, is an important and useful thing to do, and necessary thing to do, in addition to all those things. So I guess I'd a little bit make the same argument. Absolutely, we need to take the steps necessary to protect people in the here and now. And I believe the government is taking some of those steps and will continue to, including on the educational side, but also on the regulatory side. But actions that we would take to improve things now don't hold people accountable for actions that they have taken. That clearly, in my view, and in our view, means they've committed opioid-related wrongs. So I think you can do both, and we need to do both, and we must do both. And that the action in passing this bill, the legislature is sending a very clear message of accountability, and very clear message of accountability, not on some small subject, but one that has fundamentally and profoundly affected every community in our province and every community in our country.
Shall Clause 10 pass? Aye. So ordered. Shall Clause 11 pass? Aye. So ordered. Shall the title pass?
Clause 12.
Oh, sorry. I got ahead of myself. Shall Clause 12 pass? Aye. So ordered. Now, shall the title pass? Aye. So ordered. Minister.
Speaker, I move that the committee rise and report the bill complete without amendment.
Members, the question is that the committee rise and report Bill 34 complete without amendment. Those in favor indicate aye. Those opposed indicate nay. Motion is carried. This committee stands adjourned. We have little air tags attached to you all. Members, I call Committee of the Whole on Bill 36, Health Professions and Occupations Act to order. We'll start off. Shall Clause 1 pass? Oh. Recognizing.
Has anybody seen this binder? It is not.
Recognizing the member from Prince George Valmont.
Thank you very much, Madam Chair. Good afternoon, and thank you to the Health Minister and his staff. We are about to begin what will likely be many days worth of questions and exploration about a bill that is very substantive in nature. I know that the Minister has listened carefully to the comments made in the Legislature and by many of my colleagues. And as I indicated at that time, I will have several colleagues that will take the lead on a number of sections that they are particularly focused on as the critics responsible. But this is a very significant bill, and as we have said over and over again in the Legislature, it is incredibly important that we get it right, because it's not an amendment. It is, you can tell by the size of the briefing notes that it is a new bill. And it really, at the core of this work, is the public interest. This is about serving and protecting the public. Also, making sure, of course, that professionals meet particular standards, they're qualified, competent, and that they follow standards of practice ethics. So there is a lot of work that we will do, and I've always appreciated the Minister's willingness to respond and have a dialogue about the work that's before us. So with the indulgence of the Chair and also the Minister, Part 1 is really foundational to the entire bill. And we will do our very best to work our way through clauses. But what I'm hoping the Minister will allow at this point is some general questions at the beginning of this to talk a little bit about the process. So most specifically, I'm going to ask my colleague to work through some of the steps that were involved in consultation with First Nations, in particular, with Indigenous organizations, because that was part of the work that was done post the joint committee work. And so we want to get a sense of the context of the discussions, who the Minister and his team had conversations with. So what I'd like to do is ask my colleague to begin with some general questions that are relevant to Part 1, not necessarily specifically attached to a clause, but typically we get to have this kind of contextual discussion at the beginning. And so if the Minister is comfortable with that, I'm going to ask my colleague to lead off.
Minister.
Yeah, and absolutely. And, we want to be as flexible as possible. So if for some reason an issue happens and we have to go back, we just continue to ask in the section so we get all the questions answered. I just got up mostly to introduce Jonathan Dubé, who's the Associate Deputy Minister of Health and does a lot of work in this area, and Brian Westgate, who has led the enormous effort both with groups and with communities on behalf of the Ministry of Health. This is some of the most significant government legislative work that I've ever witnessed on either side of the House, and Brian deserves a lot of credit to this, and obviously I'm going to be leaning on him. So I just wanted to introduce our staff and say that we're, I think the best way to debate this will be to be flexible and not to be stuck on things, and if that means discussing a lot on Clause 1, I think that's fine.
Member.
Thank you, Madam Chair, and I should simply reflect our gratitude to the staff that are here today for walking through the briefings with us and being very forthcoming about the areas of additional work and getting back to us on a number of issues. So I think with that in mind, we feel very comfortable that we'll have a good discussion about the important parts of the bill, and we'll move on from there. So I did want to express my gratitude to the staff as well.
Recognizing the member from Vancouver-Langara on Clause 1.
Thank you, Madam Chair, and I appreciate Minister response to the member from Prince George Valemont the flexibility in terms of looking at this Bill 36, and with all the members of our opposition caucus speaking to the bill, there were lots of comments made during second reading, but perhaps members of your team would have noted some of the points that I was making in my second reading speech, which I did somewhat deliberately in order to highlight some of the areas that I would like to probe as the critic for Indigenous relations and reconciliation. Certainly to set the context, just as the Minister just said, in terms of the importance of this bill and the amount of work that was done by himself, as well as the member for Colonial Lake Country, the leader of the third party, and the ongoing work with the other critics in our caucus. It also comes at a time, of course, where there's significant work through the passage of UNDRIP, through the DRIPA Act, as well as the DRIPA Action Plan, as well as the In Plain Sight report, which was tabled in 2020. That, of course, is foundational in many ways, and I will say to the Minister that there are various points in this bill at length which relate to First Nations and Indigenous peoples, including, for example, Section 14 and the guiding principles, the reference to UNDRIP there, for example. So the purpose of asking questions at the beginning of this bill is really to have a good understanding as a foundation as we go through some of the later sections in the bill itself. So again, as the colleague for Colonial Lake Country took the opportunity to talk at great length about the level of consultation work that was done by so many others, with so many others in the province, I wanted to give the opportunity to the Minister, Madam Chair, to also outline in some detail, such that he can share the nature and the scope and the breadth of the consultation that was done with First Nations in respect of this bill as well.
Minister.
Thank you very much. And I just wanted to say at the outset the sense of priority to that consultation that was put forward by both the member for Colonial Lake Country and the member for Cowichan. It was an understanding of the singular importance of cultural safety, and given what would be the results, but given what we understood in our own consultations, the critical nature of the subsequent consultations with Indigenous communities. So I want to give the member a bit of a summary of that to begin with, even on clause one. And again, I think we just have to we'll be flexible in our approach to this. So this is not, and understanding that there may be significant debate on clause one that may be related to other parts of the bill, and I think that's totally appropriate. Obviously, any matter in which Indigenous people are uniquely affected requires very significant consultation. So let me summarize some of that consultation, and if the member requires it, I'm prepared to even be more detailed about that in future questions. But we're talking about it. There's an In Plain Sight legislation working group. They were very much involved in this with representations both from First Nations and the Métis Nation, which are very important. The First Nations Leadership Council, including in that case board and activities of Mary Ellen Turpel-Lafont and Harmony Johnson, who will be familiar to members on all sides of the House, Métis Nation BC, the First Nations Health Authority, the BC Assembly of First Nations. Broader consultation with the draft legislation took place with the First Nations Summit, which obviously includes a majority of First Nations governments and tribal councils in BC. Vice Presidents of Indigenous Health from all the regional health authorities and the Provincial Health Services Authority. Open house sessions with an open invitation to Indigenous peoples, which were hosted by the Ministry of Health and Indigenous Health and Reconciliation teams. Participation was brought, for example, from a number of First Nations from different parts of the province in those sessions. And so those are part of it. And then each part of that, if I may, has a detailed consultation that took place related to that. So in other words, there obviously was consultation at the beginning, but then both at the engagement stage in advance of legislation being drafted and then the drafting stage, there was significant consultation with the broad range of of people interested in Indigenous health and with Indigenous leaders in different parts of the province. And I might say that I think the legislation is immeasurably better for that work and that consultation, which was, and we considered it anyway, to be a test, given the importance of the legislation we're talking about, of this kind of consultation. And of course, only in future sometimes can you test how successful you were or you weren't. But I think a major effort has been put forward by everyone involved in the legislation to ensure that we went to a significant degree in that consultation and informing both at the pre-legislative step, so we didn't have a document, then everyone had to respond to the document, but the pre-legislative, and then once we got working drafts of the legislation.
Member.
Thank you, Madam Chair, and thank you to the Minister for the overview of obviously the various stages that built up to this. And just while we're on the outline, let me just ask a specific question before coming back to, of course, the reason for asking the questions in terms of meeting the requirements under the DRIPA Act. The Minister, for example, mentioned the First Nations Leadership Summit, and recently I was invited to attend that summit. I was there about 10 days ago and had a sense as to the flow of their agenda, let's say, and certainly saw some of his colleagues present to that summit. Can I just ask, just by way of example, what would be the nature of the discussion and the level of review done by the summit at the stage that the Minister referred to?
Minister.
So in the case of the summit the member refers to, it's an hour on the agenda in that case for us. And because of a lot of the work that had gone preceding to that, there wasn't a lot of feedback at that point. But that may be because some of the questions have been dealt with in advance of that and because of the work and the focus both of our Associate Deputy Minister of Indigenous Relations and all the substantial work that's been done in this area by the Ministry of Health. I think what the member suggests is true, that there is enormous demand of consultation almost that is both required but also is a practical test would be a practical test for anybody, but particularly for First Nations communities. But I think I'm hopeful that both on the specific issues that have been raised over time, which have to do directly with Indigenous communities, but also the broader legislation, which all has to do with all of us. Everyone's a patient in the system of a healthcare provider of one kind or another, that would be well represented in that consultation. So we can talk about it. I can give you more information about some of the detailed consultations, some of the detailed feedback we have, understanding that some of that feedback would be confidential, the people providing it or the questions. So I won't be listing off the questions they had, but some of the responses we have as well.
Member.
Thank you, Madam Chair. And I obviously there are many parts to the plan by the Ministry for consultation with First Nations, Indigenous communities, and Indigenous organizations, as the Minister has outlined. I am merely working through one example that he provided, which I think is a good one. It's a significant one in terms of the First Nation Leadership Summit. I appreciate the candid response from the Minister. Certainly that was my observation as well. And having been through a day-long session with the summit and recognizing the number of different agenda items that are presented to them, which covers many of the key areas of this government and the focuses, like treaty rights, land use, energy use, energy projects, clean energy, various status of various class actions. There's lots of different topics, of course, that are discussed at any given summit meeting. I will note to the minister, and I will have the opportunity to share this with others, my observation again is that it was quite clear in the wrap-up of that particular summit meeting 10 days ago that there is a general message for government in terms of the level of complexity and consultation that is coming at them being First Nation leaders, even as they sit around the table or participate online. So I appreciate that with the summit, and perhaps I can just ask the minister as he shares this, because it does help me and our members here understand the nature and the scope and the depth of the consultation. I will come back to rights on title holders in a moment, but just to talk about this key Indigenous organization, if the minister could take us through the process, I presume, and I'm generally aware of some of the members who are focused on a committee stage in terms of the body that would have been looking at that. If the minister could again go into a little more detail about what the process with the summit was in terms of this level of consultation, both pre the legislative framework drafting as well as when legislation was in draft form.
Minister.
Maybe what I'll do is take the member through the consultation, because many of the people who go to the summit are represented in all the other bodies too. So this has been the advantage of the process. But really, this engagement process starts dating back to June 2019. And original focus of that was, in that case, the First Nations Health Authority and others. The first round of consultation was focused on ensuring that articulating the ideas of cultural safety and humility be prioritized in all of this HPA modernization, and a detailed discussion of how we deal with complaints processes and the importance of consultation around issues such as data collection that the FNHA did. And that goes through multiple consultations with, for example, the In Plain Sight Working Group, an extensive session with them, the Heiltsuk Tribal Council, which had a specific consultation on this issue required, and a series more with the In Plain Sight Legislation Working Group, which was substantial, includes recommendation, includes broad participation. The First Nations Leadership Council in earlier 2022. And then as we go through the details, as we get closer, a series of Indigenous partners and organizations who took part in open house sessions around the province and had wide participation there, and continued with the First Nations Health Authority and the Summit and others. So what you're talking about really is 3 years of consultation, which assisted us in developing the sections that are in place here. And then once legislation in draft form was developed, working with us to make sure that it met the aspiration and expectation and what it intended to and was understood. I understand what the member's saying. There are a lot of issues, right? And, it was one of the themes of the second reading debate was there are a lot of issues, and this is a big bill, and so we want to focus on this, and everyone appreciates it's important, and that we have to take these things on, because a lot of the things we need to solve in healthcare we need to take on some years before they start to have an impact, and if we don't take them on, then we're that many years short of achieving the results we'd achieve. I think I would say though and you saw this reflected in plain sight, there is enormous interest in First Nations and Indigenous communities in healthcare. This isn't a case of it being secondary to resource development or anything else. I think we've spoken about this, I think, in our estimates debate when the member for Prince George Valemount and I talked about these issues in some detail. And the importance of understanding that there's a major provincial hospital in BC, which is BC Women's, where Indigenous people were leaving at, 10 or 11 times the rate of the rest of the population against doctors' advice, which reflects a concern with the healthcare system, which is profound. So I think that the issues here, the issues from the In Plain Sight report, which reflected on health professionals, so that happened subsequent to our engagement with the opposition parties, but was very much in part on the conduct and the interaction between health professionals and Indigenous people. All of that rightly informed. So we did a major public consultation in between starting the consultation on this, that was led by Mary Ellen Turpel-Lafont, that produced, I think, a remarkable report. I mean, imagine this on such a serious subject, doing a major report with recommendations that have broadly been accepted by government, by opposition, by the community in 5 months. Would we have that on all subjects of reports, right? And so that happened in the middle, and that also addressed some of these issues. So the engagement on this question has been substantial through those processes and has built one upon the other. So I understand that when we get to the end of that process, the interest might not be as high in the present, but I think the interests, and I'm sure the member knows this from talking to, in his role as critic, the interest in healthcare issues, in the jurisdiction, the First Nations health authorities, sometimes the issues of jurisdictions that stem from that. It is not a secondary interest. It is a top-tier interest. And so this wasn't a case of, producing a big subject and people had other things that were more important than they did off the side of the desk. We had engaged people involved in these consultations, and they really contributed to making the legislation better.
Member.
Thank you, Madam Chair, and I appreciate, again, the Minister's response as we delve into the nature and the scope of the consultation. And there's a couple different ways to come at this. I'll just enter one way, which is, certainly, Madam Chair, the Minister just referred to the In Plain Sight report again. And we know, of course, that report came out in December 2020, which was, almost a year and a half, I suppose, after the initial time frame that the Minister referred to when he suggested and indicated that June 2019 is when the process of consultation began with First Nations. I note that in the lead up to the recommendations at the back of the report, it underlines that all of the recommendations in the In Plain Sight report must be understood as requiring, in quotes, a joint approach with Indigenous peoples in their implementation, consistent with the UN Declaration, which calls for consultation and cooperation between governments and Indigenous peoples in upholding Indigenous human rights. There is more language around that, Madam Chair, to describe what is a fairly significant initial point in the lead up to all of the subsequent recommendations that are set out in the report. It suggests, of course, again, underlying the importance of that level, that high level of a joint approach and consultation and cooperation. And I would suggest that this statement and the way it's framed is there, 15 months after UNDRIP was adopted in the House unanimously. So I think that there is a further understanding as we work with DRIPA as to what is the standard of consultation that is needed Again, I think this is the reason why, apart from the usual, Madam Chair, that members on our side of the House will have the opportunity on various bills that come in front of the Assembly to ask about consultation with First Nations. Given what the Minister just indicated, certainly I do share the understanding that this is a high need, high priority item for First Nation leaders and elders, parents and grandparents in Indigenous communities for their children and others. This is a great need to address, and certainly there have been efforts to do so in the course of time, which date back some years, as we all know. But through you, Madam Chair, to the Minister, can I ask the Minister, was there any particular adjustment in approach when the In Plain Sight report came out, recognizing that statement? I know the Minister mentioned the meeting with the working group, and that may be part of the answer, but Madam Chair, if I can ask for the Minister to comment on that, given it was about halfway through the consultation process.
Minister.
So I think if you go back to the work that we did with the member for Colonial Lake Country, the member for Cowichan, the work done on cultural safety was very high level. And I would argue our consultation with First Nations in this case basically authored the sections involved. In both our major consultations involving the In Plain Sight Working Group, our consultations with important groups, Métis Nation BC, Leadership Council, and others, but also our detailed open house meetings with Indigenous people. And at each one of those, there are issues raised, importance of it, support raised, issues raised, and responses that are reflected and incorporated in the legislation. And so I think, I think some people sometimes in government, we see, would put forward a requirement for consultation and how it sounds like it's almost an impediment. Well, we've got to get through that to get what we want done. In this case, and this was a decision made by the member for Colonial Lake Country, myself, the member for Cowichan, in that case, was on this subject. The importance of consultation was so important that we needed to have, and developing the intent of cultural safety in the act is so important that we would say, of course we support that, but it requires the involvement, especially given what we learned, the actual substance of the In Plain Sight report, of an Indigenous people, Indigenous communities, and Indigenous groups. So those sections of the Act that are specific to those intent, including the ones that specifically mention DRIPA in the Act, but others, and I'll just give, for example, issues around the replacement of the idea of dispute with restorative processes, right? Which is a direct thing, not out of a major consultation or something that happened in the Ministry of Health offices, but about open house meetings with Indigenous people around BC where specific recommendations were made. So I think you can say that those sections of the bill involving cultural safety and Indigenous people were very much the product of a direct engagement with them about what should be in such legislation. And hopefully they're well reflected, and that's what you intend to do in the process. So this is, I would say, this changed within Plain Sight, but it was also in the mind of those who were preparing this legislation that we were going to make a change in the Health Professions Act, that one of the things that changed is our understanding of these very issues, I hope, and I think it's fair to say on all sides that's taken place. And so that meant that consultation had to be specific. In Plain Sight gave, of course, more recommendations and more meaning to that, I would say, and of course impetus to that. But I think it's fair to say that it was certainly our intent, I'd say the member of Vancouver Langara, to do that in advance of that, and the actions that were taken and the consultations that occurred reflect that.
Member.
Thank you, Madam Chair. And this discussion around consultation can take a lot of different shapes and ways, and just to work through this. And recognize that I do want to come back to the larger topic around consultation, but for example, again, with the in plain sight report, could I ask through you, Madam Chair, to the Minister, something he did refer to, which is the recommendations themselves. So just as a straight preliminary question, which particular recommendations out of the Insight report is Bill 36 addressing?
Minister.
Thank you very much, Honorable Chair. I think in particular we refer to recommendations 2, 5, and 11. So to hardwire cultural safety, and you see in the legislation how clearly that's hardwired here. Speak up culture, which is critically important in the process. And you see that's recommendation 11. And then recommendation 5, I just want to make sure I got it right, that we jointly work together to improve patient complaint processes. There's obviously significant process through health authorities of patient complaint, but there's also through colleges. And so all three of those are reflected in the legislation.
Member.
Thank you, Madam Speaker, and I appreciate the identification of that by the Minister and his team. The Minister mentioned earlier in response, and this one should be a fairly straightforward one, because cultural safety, of course, was, as the Minister mentioned earlier, something that the committee had identified early on. And so with this specific recommendation number 2, for example, could the Minister share the kind of process in receiving input, feedback, consultation around how recommendation 2 would be implemented in the context of Bill 36 from First Nations and other Indigenous organizations?
Minister.
Thank you. Well, let me describe it in some of the following ways. And I apologize because we're on section 1, and I think because the question really involves more broadly how did that impact the broader bill. So we could do that now. I think it's hardwired cultural safety in the way that was recommended by Dr. Turpin-Lafont in the guiding principles. That's section 14.2. The anti-discrimination measures, that's section 15. Making it clear that discrimination is misconduct and actionable conduct, that's section 9, sections 11(1)(c). Revamping the complaints process by enabling restorative processes that could be influenced by Indigenous practices, that's sections 157, section 268(1)(b), as well as enabling support workers and access to counseling for people who've experienced discrimination, that's part 5, division 5. And then the clear expectation for regulated health professions for providing services ethically in compliance with anti-discrimination standards set by the Regulatory College, that's 72A, in collaboration with one or more persons nominated by Indigenous governing bodies and our representative bodies, that's section 384.2. In addition, requiring the superintendent to collaborate with one or more persons nominated by Indigenous governing bodies and or representative bodies when conducting an oversight process that relates to Indigenous matters. That's section 467. These were additions to improve cultural safeties that were established with Indigenous people in BC, both at what we sometimes call the RFL stage, which people who are been in the process know is a request for legislation stage, and at the drafting stages. And you can see again, that came and was reflected at a number of stages in the legislation, but those are some of the ways in the legislation that cultural safety is found. And I know we go through these quickly. I'd be happy to share that list with the member should he require.
Member.
Thank you, Madam Chair, and I appreciate the Minister taking the time to run through that list. And obviously, it's not the intention to go through the subject matter that's covered in each of those provisions. We'll have that opportunity as we go section by section, led by the member from Prince George Valemount. But it does demonstrate, of course, the elements of Bill 36, many of the many sections that address recommendation number 2. There's one component, though, Madam Chair, that I just would like to, again, cover in that list is if the Minister could just further indicate, even in the RFL stage and what followed, what was the contact with First Nations Indigenous bodies relating to these particular proposed sections or proposed areas of the bill that would address recommendation number 2.
Minister.
I think cultural safety was at the heart of almost, we list off the many consultations we have, and was at the heart of many of those consultations. Right? And one of the things that I'm so appreciative of our team for doing, both in Indigenous health within the Ministry of Health and our team that was leading this legislation, that that Brian led, Brian Westgate led, to my right, was that what we wanted to do was to go back. And so we would hear things that we do a PowerPoint and say, is this what we heard? Because we've all been in those rooms where we understand different things. So with respect to this question of cultural safety, it was just central, I think, for the engagement of Indigenous people with the healthcare system and for Indigenous health, because it has been proven that the lack of that trust and engagement has been damaging to people's health for generations and even unto the present. Right? So a lot of that work, from specific consultations with leadership councils, the In-Place Site Working Group, the Métis Nation BC, the First Nations Health Authority, and others were very much part of it, but also in the detailed consultation, whether it was with the Health Sick or others. And they specifically informed how we developed those sections. And our approach was, on those sections around cultural safety, was to engage, listen, report back to what we thought we heard at both the RFL stage and then the subsequent stages. And I think that process was very, I don't know if it's always helpful to the people you're engaging with, because they're obviously got many things, but they felt this was very important. Certainly it was very helpful to us in ensuring that we understood what people were saying to us around issues of cultural safety and Indigenous specific racism in the healthcare system. And so that was the process that was important. What I'll try and do, and we just want to take out what individuals may have said that are in this document, but I'd be happy to share the sort of kind of broad list of consultations to show the approach that we took over time with different groups, because I think it is rare that individual public meetings affect those legislative provisions that were important in the way that happened in this case. And you have to have, I think it's the credit both of our team working on it, but also the people engaging on it, that occurred on these issues around cultural safety.
Member.
Well, thank you, Madam Chair. And certainly I would appreciate the Minister, as he has offered, to share that higher level list, whatever redactions are necessary, at least that his team seems to think would be appropriate. But certainly it would give us a better sense as to the nature and the scale and scope of the consultation process. I think that is probably the most useful example out of the report. Another example is recommendation number 5, the Minister cited. That one, of course, the recommendation is hardwired, so to speak, using that term, to refer to the BC government, First Nations governing bodies, and representative organizations, and MNBC, Métis Nation BC, to jointly develop a strategy to improve patient complaint process to address individual and systemic Indigenous specific racism. So on that one, Madam Chair, I just would like the Minister to confirm that as part of that overall consultation process, which the Minister again has indicated further detail, that for this particular recommendation, if the Minister could just confirm that was the process with these governing and representative organizations, and perhaps again give us a sense as to what that process looked like.
Minister.
Thank you, and very much in the same way, because this was, as a practical matter, there were issues around cultural safety and how to embed that in the legislation, but also the changes to patient complaint processes that are important for health authorities as well as for professional organizations like this. But it was a very similar and central part of our engagement throughout the process. And just to highlight this, because we'll come to these as we come to the sections of the bill, but we wanted to make it clear that the Health Professions and Occupations Act aligns with the BC Human Rights Code to address discrimination. That's Section 9. And it clearly addresses, and this is important in complaints process, discrimination as a form of misconduct and actionable conduct. That's 11(1)(c). It revamping the complaints process by enabling restorative processes. That's Section 157, but also Sections 268(1)(b), as well as the enabling of support workers to access, to have people there to access counsel for people who may have experienced discrimination. There further, with respects to allegations of discriminations, Section 135(1)B addresses the role of investigation committees, 231(2)B, again, to do the same, and 170 with respect to those are all actions that were informed by this. And oversight overall the complaints process, which is Section 467 of the Act. And so these and the providing opportunities for confidential and or admissions, anonymous submission of a complaint, which were all issues that both were raised and reflected in the legislation. So that complaint process, that recommendation 5 is reflected directly in the complaints process and then through the legislation. Some of those changes are the same as cultural safety because the complaints process has that embedded in it, but others are directly to the complaints process. So again, those were issues that were subject of in plain sight, the recommendations of in plain sight, central to the putting in place of cultural safety. How does one engage in complaint processes using and ensuring cultural safety? And those are reflected through the legislation. And those are important considerations for us in our consultations throughout the process, both with the in plain sight working group, with which is substantial and representative, as the member will know. Having had that discussion, I had that discussion with the member for Prince George Vale Monitoring Estimates, but we know these, and we would be happy as well, because the member may be interested in this outside of the legislation, for our Associate Deputy Minister to bring him up to date as to progress on in plain sight that goes beyond this legislation, because I think that's important, but with also the representative groups and our public sessions as well. So all of that informed these key aspects, and I think you see them reflected, and we'll see them reflected as themes as we go through the legislation.
Member.
Thank you, Madam Chairman. I certainly appreciate the further offer by the Minister to have an opportunity. I know that the member from Prince George Valemont has already been into that, but certainly it does anticipate my next question in terms of the other recommendations in the in plain sight report. Certainly would appreciate that further briefing for recommendations that are not specifically addressed, that the Minister did not identify. Having said that, and I'm not going to attempt to question the Minister here at this juncture about every other recommendation in the in plain sight report, but I would ask the Minister if he could offer a comment about recommendation number 4. Recommendation number 4 says that the BC Government, First Nations governing bodies and representative organizations and MMBC jointly establish the Office of the Indigenous Health Representative and Advocate with legislative recognition and authority to provide a single, accessible, supportive, adequately funded resource for early intervention and dispute resolution for Indigenous peoples who require assistance to navigate, fully benefit from, and resolve problems within BC's healthcare system, including all health authorities, regulatory colleges, and other health providers. So, and then talks about a review within 5 years. So, Madam Chair, to the Minister, I know that there obviously are roles and responsibilities for the new Superintendent's Office, and we can get there in terms of questions about those, the nature of that authority and the jurisdiction and the mandate. But through you, Madam Chair, to the Minister, could I ask the Minister to comment on recommendation 4 and whether there are elements here that he considers that are been addressed in Bill 36?
Minister.
Thank you. I think what I would suggest for the broader questions on in plain sight, which aren't related to here, is that we're absolutely prepared to have a briefing with the Associate Deputy Minister Dougfir to go through where we are in all of the recommendations. And this is an interesting reflection and lesson for ministers and ministers of health. When we went through this process of implementing in plain sight, we went through a very significant governance process to ensure that working groups around it were representative. In other words, that we didn't simply replicate previous models that weren't working again. It was a sort of we know what's best for everybody approach. So that's what we've done in all those. Recommendation 4 is not maybe about health regulatory colleges, but it has to be embedded everywhere. So of course it should be embedded here. But it was principally about a broader health system process of concern. And there are roles for independent officers to play, and there have been since the in plain sight report came out. So be happy to go through in detail what we're doing to respond to that recommendation, working with the team we've put in, the very representative team we've put in around in plain sight to see that recommendation be approved, to be moved forward on in a way that makes sense. So with respect to this bill, creating another office or adjusting ombudsperson's offices and others to ensure that we meet those needs, that doesn't take away your responsibility for this legislation to meet the requirements and the necessary conditions of cultural safety. So one is not, sometimes we create something over here and we say, oh, we're dealing with it over here. It's embedded in the legislation for a reason, because it's our expectation that, that health professional colleges, that the regulation of health occupations, and that the oversight of those have at its heart anti-racism and anti-discrimination. So that would be in addition to those actions. So so when you talk about recommendation 4 of the report and the progress we're making on in plain sight, it's important, but nothing we do there would take away the obligation in this bill to make sure that our legislative commitment, our unanimous legislative commitment to DRIPA, our unanimous commitment to the in plain sight report and seeing it go through, and the centrality of cultural safety and complaints process that are culturally safe in a way that's worthy of its name, and a speak-up culture are central to the legislation. And what I can tell you is that in addition to in plain sight, in the spirit of in plain sight and in the spirit and the requirement of DRIPA, that's what we've tried to do here by having those sections be specifically and comprehensively informed by Indigenous people.
Member, noting the hour, one very brief final question for today.
And appreciate the response.
He wants a brief answer.
So, speaking of DRIPA and the action plan, through you, Madam Chair, to the Minister, would the Minister just identify which specific action items of the DRIPA action plan are addressed by Bill 36?
Minister.
Thank you, Honourable Chair. And with respect to the DRIPA action plan, which happened coincident with our drafting of this legislation, I should say, I want to cite 3 particular items, 3.7, 4.8, and 4.14. And perhaps what we'll do, because we're at time here, is I'll give those numbers to the member now, because he may want to follow up to them when we come together next. But 3.7 is actually to implement the recommendations of in plain sight, right? So that was part of the action plan. And so section 4.8 is related to tripartite health plans and agreements, and to ensuring the participation of decision-making. And section 4.14 is about the increasing the availability and accessibility of resources to Indigenous partners. So we can go over those in greater detail as we go forward, but that gives the member a sense and maybe a focus to where we would go next. And so I want to give them those answers and move, Honourable Speaker, that the committee rise, report progress, and ask leave to sit again.
Thank you, Minister. Members, the question is that the committee rise, report progress, and seek leave to sit again. Those in favour indicate aye. Aye. Any opposed indicate nay. Seeing none, motion is carried and this committee stands adjourned.